Good morning, everyone. My name is Richard Jolly. I'm a practicing attorney in Los Angeles, California, and also serve as a fellow for the Civil Justice Research Initiative out of UC Berkeley School of Law. As everyone is getting settled, I want to let you all know about programs currently being offered here at UC Berkeley. Berkeley Law Executive Education, which oversees the Berkeley Boost webinar series, offers a range of professional development programs for attorneys, business people, and those working for government and nonprofits, and they have two upcoming programs that we think might be of some interest. The first is called Sustainable Capitalism and ESG Online. This course demonstrates how to incorporate environmental, social, and governance considerations into business strategy through a combination of focused lectures and case studies, curated readings, and in-depth interviews with over 50 thought leaders. The second program is called Leadership in the Legal Profession. This is a business school style virtual course for attorneys who want to advance their leadership, people, and project management skills. And if you apply today, there are some early bird discounts for that. You can learn more about Berkeley Law Executive Education and their programs on their website, executive.law.berkeley.edu. Well, right now, I'm very excited to meet everybody and welcome you all to this 8th episode in our series of Berkeley Boost webinars. Sponsored by the Civil Justice Research Initiative. The CJRI is an academic initiative that explores through interdisciplinary university-based research how the civil justice system can be made more available to everyone seeking relief. You can learn more about the work of the CJRI, including its diverse research, publication, and public programming by visiting our website at civiljusticeinitiative.org. The goal of this series of webinars is to explore the impact of important issues currently facing civil justice, be that in light of COVID-19, police violence, or, as we'll be covering this week, elections. With each episode, we aim to offer perspectives from legal practitioners, scholars, and jurists. And we invite audience participation. So please feel free to submit questions using the Q&A feature at the bottom of the Zoom, and we will address them throughout our conversation. Today's episode will focus on civil remedies for voting rights violations. And we can have no more qualified guests to speak on that topic than Kristen Clarke and Justin Levitt. Kristen is the president and executive director of the National Lawyers Committee for Civil Rights Under Law, one of the country's most important national civil rights organizations. The Lawyers Committee seeks to promote fair housing and community development, economic justice, voting rights, equal education opportunity, criminal justice, judicial diversity, and more. Justin is a professor of law at Loyola Law School in Los Angeles. Before being a professor there, he served as Deputy Assistant Attorney General in the Civil Rights Division of the Department of Justice, where he primarily supported the Civil Rights Division's work on voting rights and protections against employment discrimination. Thank you so much for joining us today, Kristen and Justin.
Of course, our pleasure.
To sort of get us going, Justin, I was hoping you might be able to provide us a little bit of context about why is it important, historically and today, that we discuss various types of civil remedies for voting rights violations?
It's primarily because voting is different from virtually every other activity we undertake as a society. In most of law, we think of remedies as taking place after there's been damage done in order to try to make the person whole. It's not always possible, obviously, but that's the goal. That's the goal also in most other types of civil rights law. So housing law, you try and get somebody put back in housing they were originally in, and you try and work out back rents so that you make them financially whole. Employment law, you do the same. You try and make sure somebody can have the job they want or the position they want, and you try and make sure they have back pay to make them financially whole. You can't do that with voting. Once an election has happened, it's happened. And if an election takes place in a way that's discriminatory, that means that while you're trying to fix the elections of the future, existing lawmakers are there making law in the meantime. And so you can't ever get an election back, which makes the question of remedies really important before an election ever takes place. Remedies are also really important in another context. That is, after we've had an election, we're seeing this literally right now, people who want to suggest that there may be some improprieties with the laws or conditions under which those elections were held may try to throw out a lot of ballots cast by voters who were just following the rules at the time. And so remedies are also really important in post-election proceedings to make sure that voters who thought they were following the rules aren't penalized if there happen to be small mistakes by officials. Now, actually, given the chaos of the moment, we know there have been very few mistakes by officials. This election was very clean. Every time I bring up there might possibly have been mistakes by officials, my dog gets very upset. But the attempts, nevertheless, to undo elections that we've had come way too late. And that's a remedies problem. It's fundamental and it's really specific to voting.
Kristen, do you share those thoughts? This idea that remedies in this area is unique from remedies in other areas of our law.
Yeah. So first, let me say it's a pleasure and an honor to be here, and wonderful to be here with my friend and expert in this area, Justin Levitt. So I think remedies are incredibly important at a moment in which we're seeing widespread and rampant voter suppression that is unlike voter suppression we have seen in modern time. Let me walk through a few examples of what we've been contending with this election season. Robocalls, for example. Robocalls that impart false and inaccurate information to voters with the goal and intent of discouraging people from freely casting their ballot and participating. We saw that with two operatives this season who intentionally targeted Black voters in cities like Detroit and Cleveland. They issued robocalls essentially instructing people that if you provide information on a vote by mail application, it may be used against you. That information may be turned over to authorities and used to pursue enforcement actions against you. I mean, this was a scheme that was very intentionally calculated to discourage Black voters and other voters of color in particular cities from voting. And we filed a federal lawsuit under the Ku Klux Klan Act and under the Voting Rights Act, alleging that this was a form of voter intimidation. And the remedies that we are seeking are monetary damages to hold these two operatives accountable for the damage that they have done. But the other forms of relief that we sought in this case include requesting that they issue a remedial call to those targeted voters, requesting that they stop the behavior, and we were successful in securing a TRO, which barred them from, going forward with similar kinds of robocalls in the future. And I think that that's important because it's a precedent that can help to discourage similar mischief and bad conduct on the part of other bad actors out there, right? This conduct, if left unchecked, means that other operatives may deem this open season and may deem this a moment where they too can employ the strategy of using robocalls as a way of suppressing votes. So the remedies are not only about holding the bad actors accountable, but it's about making sure that we have a precedent in place and a deterrent to other bad actors and operatives out there. I'll just close out with one other example from North Carolina, Alamance County, North Carolina. There we had a group of Black Lives Matter demonstrators and other activists, including religious leaders, who held a peaceful march to the polls. And several days before the close of early voting, they worked with local law enforcement and said, look, we are planning a march, a peaceful march to the polls, and we want you to make sure that you are protecting us, protecting the participants in this march. And we worked with them to ensure that law enforcement would do just that. Instead, law enforcement turned on these peaceful demonstrators. They were led by a minister, Reverend Greg Drumright, and law enforcement fired pepper spray on this crowd that included children, locked up many of these demonstrators, and the result was many of them were not able to vote. Many of them could not participate in early voting. This was on the last day of early voting, where they were trying to drive a critical mass of voters out to the polls. And you can register to vote on that day. It was the last day to register to vote for the 2020 season. So some people were not able to vote literally because of law enforcement's conduct. So there we are seeking remedies. We are seeking TRO to stop this abusive conduct on the part of law enforcement officials who intentionally interfered with the right to vote. And we're also, again, here using the Ku Klux Klan Act as a way to hold. Here, the bad actors are both city officials and law enforcement who conspired and worked together to silence this group of peaceful demonstrators. And the remedies piece of this fight is again critically important because we want accountability and we need a deterrent that sends a strong message to other bad actors out there about conduct that we won't tolerate in our democracy.
What is the hook in the Ku Klux Klan Act? What is the how is that enforcement as a statute work? What does it provide for you as an attorney bringing these types of suits?
Yeah, well, it's the conspiracy essentially between city officials and law enforcement officials who work together to interfere with a protected right, here the right to vote and the right to peacefully demonstrate. And that's what this group was doing. And it's unfortunate that we are in a place in 2020 where we still have to resort to these, laws that were put in place during a very dark moment in our nation's history, but a reminder that we still are in a dark place and fighting some bitter battles when it comes to voter suppression and racial violence and interference with protected civil rights like the right to vote and the right to protest.
What other statutes are there or hooks that can be used to find or to award civil remedies to try to correct these harms that are occurring? Are there state statutes that can be looked at? Are there other federal statutes? What can be done?
Well, I'm sure Justin wants to jump in here, but Section 11B of the Voting Rights Act is another critically important tool and another tool that we've had to resort to using more often in this era of unprecedented voter suppression. Section 11B of the Voting Rights Act prohibits voter intimidation. And that's what we're seeing. I mean, we've taken a stance that these robocalls are a form of voter intimidation, that law enforcement's use of force against people, peacefully marching to the polls is a form of voter intimidation. But that's another important tool in our arsenal.
Yeah, and I'll just add, so you've heard Kristen talk about some of the litigation that she and the Lawyers Committee have brought, which is at once really, really innovative and also centuries old, right? As she mentioned, it's a very old tool that's finding new purpose. In addition to some of those, there are federal laws that each have robust remedial mechanisms: the Voting Rights Act, the National Voter Registration Act, the Help America Vote Act with some remedies for federal government and fewer for private parties, the UOCAVA for uniformed and absentee voting for citizens abroad. But as you mentioned, most of the rules on voting, and therefore most of the remedial procedures, are actually found in state law. So there are powerful federal statutes, yes, that provide cross-cutting relief in some circumstances. But in all the litigation you heard before the election and most of the litigation that you're hearing now, those are really state cases or constitutional causes of action, where the remedies are typical remedies found in state cases or typical remedies found in constitutional causes of action, with the exception that it's rare to seek damages, as Kristen and the Lawyers Committee are doing, because it's rare to have private parties that are engaged in this action. Most of the voting suits out there are against public activity, against government activity for not doing what they should be doing or doing what they shouldn't be doing. I'd also be seriously remiss if I didn't mention the most powerful remedy of all, which we don't have right now. So the Voting Rights Act of 1965 was originally configured with the singular powerful remedy to stop some of the whack-a-mole that you see around the country, to stop responsive litigation, which is really costly, is really burdensome, can be very effective, but takes too long to come to fruition. And that's not a fault of the litigators. Kristen and the Lawyers Committee are exceptional litigators doing exceptional work. It just takes a long time to get to a remedy in a court. The Voting Rights Act originally had a provision for the actors with the worst history of race relations, with the most troubled history, that stopped discrimination before it could start. This was a provision in certain jurisdictions that required the jurisdiction to run any change by either the federal government or a court in DC. In 2013, the Supreme Court said the formula for figuring out where that pre-clearance provision, where that strong medicine has to be applied, isn't up to date enough. And so, very controversial decision, one that I still have a really hard time teaching to students because I just don't buy the rationale. But be that as it may, 5 people in robes said that the formula was not sufficiently current. The mechanism is still there. This is really important. It's just that Congress needs to update the where for that existing mechanism to take place. And until that happens, until we get a mechanism for stopping discrimination before it occurs, we're going to have to rely exactly on the sort of deterrence, on the sort of injunctive relief that Kristen talked about, which is effective, but not as effective as we need it to be going forward.
It sounds like it's effective, maybe not in 2020 right now, but hopefully in 2022, 2024. Pre-clearance, of course, would be, perhaps that would be the most effective, as you suggested. If we are unsuccessful in getting in updating the formula and getting a pre-clearance that could pass judicial review, what are civil remedies that would be sort of after the fact that might be productive? I understand that the timing makes this very difficult, but what tools could be employed? What tools do you need to make sure that these types of harms either are curtailed or are corrected?
We need federal courts to grant temporary relief or preliminary relief when people come to ask, and not have to require a full case to be made, which takes, as you know, years and an enormous amount of both evidence and money. And in that time, discriminatory laws and policies are being passed and implemented. We need some creative financial deterrences, just as Kristen's mentioned before. I'll say we need appellate courts to stay out of the way of lower trial courts when they issue injunctions in a fashion. This last cycle, we saw an awful lot of appellate courts come in at the last minute and without explanation, without explaining why they did it, they pressed pause. They issued stays that end up being decisive for any coming election. The Supreme Court's really been the most guilty of this. It's used as shadow docket, this stay power, without explanation, increasingly over the last few years. And it's something that's really disturbing because it feels a lot to lawyers that have worked really hard and judges that have worked really hard on crafting very narrow, very tailored injunctions. Like the courts are just exercising raw power and not doing law. When they're not explaining what they're doing, when they're just saying, stop, and we'll get back to you in a second, that feels like a sheer exercise of power and feels very improper. There were a couple cases that would have given real relief to real voters in the midst of the pandemic before this last election that were prematurely paused without explanation by either the courts of appeal or by the Supreme Court this last cycle.
Yeah, I echo Justin on that point. We brought a number of suits during the pandemic to deal with issues like unnecessary restrictions on the number of drop boxes per county, premature deadlines for returning ballots, and secured important victories that ultimately would have provided more access for people to participate this election season. And those victories, sadly, were often, not always, but reversed at the circuit court level and proved detrimental at the end of the day for voters who were overcoming tremendous obstacles during this unprecedented election season. I just also wanted to talk about Section 2 of the Voting Rights Act, which is no substitute for Section 5. And my hope is that we'll see this Congress take action to renew and restore the Voting Rights Act and pass the John Lewis Voting Rights Advancement Act so we can get the preemptive provisions, that prophylactic, back in place. We need it to help prevent a lot of the ugly voter suppression efforts that we have seen in many states. But I I'm also thinking about redistricting, which is the next kind of battle that we face for those who care about democracy. And as we talk about remedies, I think redistricting is actually a moment where we got to think far in advance about all that we can do to ensure fair maps at the outset. And that to me will mean really engaging the public and harnessing the energy that we've seen this election season and moving it towards the redistricting process and ensuring that we have open public redistricting processes where the public has a fair opportunity and is given notice on how they can participate, and hopefully not see the kind of monsoon of litigation that otherwise awaits us, given that this will be the first redistricting cycle without the full protections of the Voting Rights Act in place in many states.
We're getting some questions from the audience. There's one that is of interest. You mentioned, for instance, when somebody gives a robocall and it's fraudulent, one remedy might be for them to call back and say, I don't actually know what they would be forced to require. I guess it'll tell them that the previously fraudulent call was fraudulent. But there are certain types of harms that can't really be corrected. The question here is about hacking. If voting machines were hacked, if that actually did occur, what would be the remedy in that type of circumstance?
So I'll take a quick stab and then let Kristen comment if she wants. First of all, appreciating the question, I think it's really important in this era of misinformation and disinformation to emphasize that there has been no evidence whatsoever of hacking of machines or systems, the actual systems used to tally votes or cast votes in either 2016 or 2020. So this is a great question, but I want to make sure people know a hypothetical one so far that's really important to emphasize. Part of that's because the systems are pretty secure. They actually are pretty secure. So when there was hacking of the election process in 2016, and there's documented evidence that a foreign military unit hacked our election process, but they didn't hack the ballots or the tallying systems or the counting systems. They hacked us. We are the weak link. The information we receive, the information we pass on to others, the things that get us really hot and bothered. And so far at least, the damage has been done to us and our information and not the systems. That's in part because there has been a tremendous amount of attention in securing against cyber attack, both globally and locally. The systems that are used to cast ballots, the systems that are used to tally ballots, the systems that are used to report ballots. And here I actually give the federal government a fair amount of credit. Over the last couple of years, they have worked with state and local partners to really make sure that those systems are as secure as possible. The first remedy is to figure out that something has been happening. So if we were to be hacked, the first thing you need to know is, has it happened? The best way to do that is through an audit process. And there are a number of states that have conducted audits long before this year. There were a number more that conducted audits in this year. I will hope that that becomes a persistent feature of the election process going forward. It's a quick double check. Do the individual counts of small percentages of ballots back up what we think the systems overall have shown, or do they show that there's been a problem? And statistically, you can count a fairly small number, you can audit a fairly small number of processes in order to get a very good feel for whether anything's happened. If something were to have happened, again, hypothetically, in the past where there's been widespread questioning over the conduct of an election, courts have sometimes authorized or required a do-over. That's much easier to do in a state legislative race or easier to do in a congressional race than it is obviously in something like a presidential race. We've never had that situation happen in a presidential, and God willing, we never will. But there are various remedies that account for elections that take place where there's really cause to question the election structure as a whole. Still, the best remedy for a situation like that is good defense ahead of time. Nobody wants to be in a position of having to fix a problem of that magnitude afterward.
Yeah, I'm encouraged by a lot of the reports that indicate that this was a safe election when it comes to kind of cybersecurity, and that there is no evidence of massive widespread hacking that we're aware of. But I do think it's worth noting that there are a number of election security bills kind of sitting in the Senate that would have provided more tools in our arsenal to ensure relief and ensure that we are able to seek remedies should bad conduct unfold. One of the bills would have required campaigns and candidates to disclose foreign offers of assistance. It is remarkable that we have in place a status quo that allows a candidate to receive an offer from a foreign country seeking to interfere in our election, and there is no obligation or duty to disclose that to federal law enforcement officials. And there is another bill that would prohibit officials from connecting voting machines to the internet, and several other bills as well. So I just want to observe that while hacking did not prove, as far as we know, to be a major issue this cycle, that we are in need of stronger laws that can help to ensure that we can pursue remedies, to ensure that we can hold people accountable, entities accountable, and ensure that the participants in the ecosystem, the campaigns and the candidates, do their part to speak out and disclose information that might help to prevent an issue that might otherwise prove disruptive on election day.
Justin made an interesting point about the idea that it is us who have been hacked, and this disinformation campaign that occurs through fraudulent phone calls, through posts on the internet, through foreign adversaries, and how this targets specific communities. We have another question from the audience asking about formerly incarcerated voters and how they have encountered problems, and perhaps fraudulent as well. What has been your thoughts on formerly incarcerated individuals, and do you have any resources or organizations that you might be able to identify that might help them regain their voting rights?
I know Kristen's going to want to talk about Florida, so I don't want to cut that off in a bit.
Yeah, no, Florida is such a bittersweet story, right? Long-standing law on the books, racially motivated, a racist law that sought to lock and exclude Black people from participating in our democracy because of criminal histories. Then you've got the voters who respond with Amendment 4 and say, relic of a bygone era, let's move forward. And then a legislature on the back end that takes action to make that right contingent on payment of fines and fees in a system where it's virtually impossible for people to even understand how much they may owe or figure out how they pay off debts, and people who face barriers to reentry. And so, often paying off these debts prove to be a true obstacle. Lots of litigation that went back and forth up through the 11th hour. But this is still a real issue. There's still a number of states that have these laws on the book that disenfranchise otherwise fully eligible Americans from our democratic promise just because of a mistake in their past. And it's not the kind of democracy that we should tolerate in 2020. We want a democracy in which we encourage everyone, no matter what walk of life they're from, no matter what mistake they may have made in the past, no matter how much they may be profiled unfairly by law enforcement. We want a democracy where all of these voices can participate and shape who's sitting at the table and making decisions. And so we still have some work to do when it comes to eliminating kind of racist disenfranchisement laws from the books.
I can't tell you guys how much I appreciate you taking the time to meet with us today. Unfortunately, we are all out of time now. But thank you, Kristen and Justin. I also want to thank the executive director of the CGRI, Ann Bloom, as well as the people at the Berkeley Law Executive Education for helping to make today's discussion possible. Finally, before we sign off, I want to let everyone know that while this is our last Berkeley Boost, CGRI Berkeley Boost of 2020, we do plan to be continuing these webinars next year. So please keep an eye out as we announce more episodes exploring critical issues and access to justice. And again, thank you, Kristen and Justin. It's just been such a joy speaking with you this morning.
Thanks for the invitation, and thanks for the opportunity to be with y'all.
Yeah, thank you for having me. A pleasure.